buddy.
Who is that cat? Arthur. You're just gonna stare at me? Oh.
I am Walrus. What the hell?
Hey everybody, it is Artie of Artie's Corporate Fiction. How you guys doing this evening? Hope you guys had a wonderful Memorial Day for those of us here in the States and those who also celebrate it. I was able to spend time with some family down at the shore. Y'all probably saw my YouTube shorts there. It was a lot of fun. I went fishing, caught nothing, but you know what? That's if fishing was about actually catching fish, then you know it would have died out a long time ago. So this I was given a heads up of this video from, oh no, he's gonna hate me, Tommy V in MI, or Tommy V in Michigan. He sent me a link to this of this. I appreciate him doing that, so I'm shouting him out. Mandy, if you I think he says he does have a YouTube channel that he's just starting. So Mandy, if you can find that and post that link into the chat and give him a shout out in the description when you get a chance. So shout out to him for sending me this. I believe Law Talk with Mike has already saw it. Old Squishy Gardener has already posted about it. And it looks like we're going to take a look at it as well. I had seen the first 15 minutes of it. I already know that for whatever reason, the judge is going to give him a lot of leeway to spout a bunch of nonsense. But, you know, we're going to endure it together. The issue that we're having, though, is this guy is not... He is a Darrell Brooks. 2.0, and not so much in the sense that because Darrell Brooks wasn't a Moor. The problem was, like Darrell Brooks, this individual is not facing a mere traffic citation. This is not a mere eviction or arrearages on rent. There are some serious charges that have been put on him. And we're going to listen in on that. And that's kind of where we get irritated. That's where I get irritated the most, is whenever people who are trying to pull this BS, but dealing with actual allegations of harm. So be prepared. Get yourselves ready. So sit back, relax, and let's try to have some levity while playing bingo.
Can't think everybody has to pay for it.
Let me see here. Believe.
All right, we're on the record.
There we go.
Stevenson, Michigan versus Parnell Michael McCreary. 2356485. Mr. McCreary is charged with count 1 assault, 6 murder, count 2 assault. To be written by the time less than
Okay, so you guys, I'm gonna try and put up the gain on here so you guys can hear it better. But if you didn't hear it, her the first time, the first two charges are attempted murder and attempted SA. And then the other counts are weapons related charges. Because I believe he's a convicted felon to begin with.
Murder or by strangulation. Count 3, weapons, firearms, possession by felon. Count 4, weapons, ammunition, possession by felon. Count 5, assault with dangerous weapons, on assault. Count 6, 7, 8, 9, 10, weapons, firearms, habitual offender, fourth offense. Set for a hearing today. Appearances.
Edwin Milwaukee, P5488, appearing on behalf of the people.
And Lauren Yerseskian on behalf of the people, P67104.
Darrell Michael McQuarrie Gill on lowercase, natural person, not a person. If I may ask.
All lowercase, not a natural. What do you say? A natural person, not a person, or something like that. So we're already starting off strong.
This board question will address the court.
And I believe this.
Good afternoon, Your Honor. Earl Washington, Neighborhood Defender Service, P31383, as the standby attorney.
Standby counsel. That's what I thought.
What's your question?
First, I would like to object, no disrespect to SY here, but he does not represent me.
I know that.
Okay. Yes, but the prosecution.
Your objection has been noted on the record.
And the
You have a
prosecution and them are.
You have a question?
Yes.
What's the question?
I didn't know that the court would allow the prosecution to commit felonies in violation of state and federal
That's
law.
not a question, that's a statement. Okay, so we have a. appearance on the
Also,
record.
the question
You're not
is.
gonna talk with me then.
All right.
So we have Attorney Washington as standby counsel. He does not represent you, but in the event that you need help, he's there to help you. This is your request that we're on here today, so you can begin with your request to the court.
I don't, he's not representing me.
We've already established
Yes.
that. So you can begin.
Yes.
I have your documentation here, so you can start.
I haven't had anything from the prosecutor's office. You gave the prosecution 2 orders to give me discovery under People versus Davey. The 225 Michigan Appeals 592, violation of a discovery order is grounds for dismissal. Also, I would like that the court, as well as the people, provide their bond numbers, their licenses to practice law. Yes, and their oath of office. Because
Oath of office.
right now, at this
Oath of office. So if you got that one.
point, I'm being violated. I would like to also have Kim Worthy here, the chief prosecutor, because she has committed crimes past and present. I would like a change of venue because DPD has been continuously retaliating over the years. It's well documented. People have been lying, making false complaints. They're using known perjurers. I've made reports with Detroit police, and I'm not being given the same rights as any other citizen. If a person is being called in and they're saying, well, hey, Mr. McCurry did this and did that. They come to my house. They bang on my door. They're impeding upon my freedoms, my sovereignty. They're a corporation. Corporations cannot act upon natural persons. Now, the case of Coins versus Virginia, 19 U.S. page 264, says that it started in D.C. They incorporated inhabitants of D.C. and the states, other states. I am not a corporation. As I stated numerously in the beginning of this case, ab initio, I reserve my rights not to be compelled to perform under any contract or commercial agreement. I am a Moor's national sovereign. This court, as well as the people, have violated the Moroccan-American Treaty of Peace and Friendship of
Treaty of Peace and Friendship. There you go.
28 June of 1786. Now, this quasi-contract that I presented to the courts, per the Michigan Supreme Court, the U.S. Supreme Court, this matter has already been litigated. And this court, as well as the people, are in default. And again, they refused to give me their bond numbers, their names, and things of that nature so that I may properly file a lien in the federal court, as well as I'm preparing a 42 U.S.C. 1983 case. Again, the state has no duty to protect private citizens from private citizens.
Yeah, I don't know why he's citing a default judgment in a criminal case, but I mean, Juan Galt, you know more about that than I do.
Under the Shaney versus Winnebago Department of Social Services, 489 U.S. 189, 1989. If you go all the way back to the civil rights cases, the 13th and the 14th Amendments were created to protect African Americans from discrimination by city, county, and state and federal governments. And it also says in this case as well that they have no duty to protect private citizens from private citizens. So to compel.
They don't have a okay, this is where it actually starts to anger me, because if I'm understanding his argument here, where he's claiming that the state does not have a duty to protect private citizens from other private citizens. So is this the angle that he's going with in this charge? That because his actions were committed against another private citizen, the government or the state has no jurisdiction over him? That's what it sounds like. But I guess we'll find out more.
Performance of these corporate statutes, which it speaks about in Coins versus Virginia, again, 19 U.S. page 264, they created statutes to corporately punish the inhabitants of the city of Washington and the District of Columbia, and it went down into the other federal territories as well as the cities, counties, and the state governments. And they're committing fraud against the people. These these statutes that they have me charged with are unconstitutional. And I ask even though you're in default, I'm giving the state another chance, but this right here is already locked in. They're in default because the law says where they have a legal or moral duty to respond. Their silence is their acquiescence, their tacit agreement.
I keep forgetting to add some of these names, like silence is acquiescence or tacit agreement. The other one, he's going to, I only got about 20 minutes into this. It's about 48 minutes long. I've only gotten about 20 minutes into this. But he also, cites, Dred Scott. I feel like I also need to add that as a box, at least for the Moors, because I noticed that the Moorish sovereign citizens, they love citing Dred Scott for some reason.
So they're in default, Your Honor. And I would ask that the court subpoena Kim Worthy here so that we may put her on the stand to answer for her subordinates' criminal behavior as well as her criminal behavior. Have documents here where it's clear that they, can I sit down for a minute? My back is kind of bothering me. That's my leg to shake. But I would like Kim Worthy to be brought in so that she can be questioned about the change in venue, the allegations, which are factual. When they sent me to prison for 15 years and 8 months for no crime at all. Judge Kirsten Frank Kelly was in Wayne County. She issued an order against me that was null and void. I was railroaded, sent to prison, did 15 years and 8 months where I lost my mother, family time away from my daughter who's now 24 years old. She's a mother. I'm a grandfather. I've been productive in the community since I've been home. They're trying to make me look like I'm a demon. But the paperwork shows the opposite. And I would like all of these things. I would like an evidentiary hearing so that we may put these documents into evidence and that this case can be properly litigated because the prosecution is committing crimes. So I ask that this court use this subpoena power and adhere to their oath of Article 6, Section 2 of the U.S. Constitution, as well as Michigan Code of Judicial Conduct, Canon 2B. And the paperwork is clear. They refuse to respond. Everything that is happening now is criminal. In violation is conspiracy, 18 U.S.C. 241, and in violation is Michigan misconduct in office, MCL 750.505. I have been humble with this court. I haven't been here just trying not to disrupt the court. I'm under threat, duress, and coercion. You know what I'm saying? They have constantly been retaliating against the Detroit police as the sheriffs, as well as Kim Worthy's office. And it's well documented. They sent me to prison off the testimony of a perjured witness.
Oh,
I would like all.
He just said it too. If you have threat, duress, coercion, I believe that's on here. It's not on my bingo card, but it's on there. If you have threat, duress, or coercion, go ahead and mark it. Or if it's under, or if you have it as under duress, I'll count that as well. who was it that somebody was actually asking me a question? Oh, John asked if I had seen the woman in Jamaica that pulled this. I've heard of it. I have not seen it yet. I'm saving that for another live stream. But I've heard of it, but I haven't seen any of it yet.
Needs to be adjudicated properly in this matter. And jurisdiction has been challenged per federal and state case law. The people have to prove jurisdiction. They have statements. The corpus delicti rule bars statements as hearsay out of court.
Corpus delicti.
This is what they
Corpus delicti. If I don't have that one, it should be. But I'm pretty sure corpus delicti is also there.
one is they cannot make an affidavit for anyone. You see what I'm saying? My brother, as they claim, made these statements. I still haven't been given any discovery or anything. And they're in violation of the Michigan court case law, Court of Appeals case law, and People versus Davey. This court clearly twice told me to give them discovery, 225 Michigan Appeal 502. And they're still violating the court's orders. And this court, honorable court, should exercise the contempt powers and have these officers supposedly acting for the court, which are being criminal, to be put in jail until they comply and or fined. Detroit police has a history. They were prosecuted by the Department of Justice in 2001. Then they were under.
I actually don't know. Has he mentioned jurisdiction? I actually genuinely don't know.
The consent decree into 2013. And they're still committing atrocious criminal behavior and acts against natural persons, natural citizens. You know, Judge, you're familiar with this case law. You're a licensed attorney and an elected or appointed judge. I don't know. But the Supreme Court under Marbury versus Madison rulings, they're decisive, let the decision stand. This court is bound to adhere to Supreme Court rulings. These statutes in which they're charging me with are unconstitutional in violation of the civil rights cases, as well as Cohen's versus Virginia, the Supreme Court. And today, again, I respectfully compel this court to adhere to these things. And the Supreme Court says where a court does not have jurisdiction to act, or where they don't have jurisdiction and refuse to act, it's considered treason against the U.S. Constitution, Your Honor. And the paperwork is clear. All parties that I've served these papers on are in default, Your Honor. And I ask that this court, like on page 13 and 14, I clearly stated in the offer, I'm the offerer, they're the offerees. And this process is approved by the Michigan Court of Appeals, Michigan Supreme Court, in which they cite federal court case law and the federal court cases, cite these cases as well.
No, he has to say common law, Jessa. He has to say I'm being pedant, I'm being banal about this. He's got to actually say common law.
Give me a second, please. On page 13, it says, offerees 1 and 2 agree that all above and below statements are true, and they have until May 24, 2023 to admit or deny the above, and agree that terms, A, failure to hold state laws unconstitutional, and void ab initio, agrees to give me in the sum of $5,000 in gold and silver coins and or Federal Reserve notes and assets in their personal and official capacity. B, failure to dismiss charges with prejudice and grant all of the above, all of the supra and infra, agreed to give me $500,000 and agreed to be charged via MCL 750, 505, 18 USC 241, 18 USC 242 by the U.S. Attorney and the state's attorney for their crimes via Turner Associates Inc. versus Small Parks Inc. 59 Federal subsection 674 at page 680 through 82. Eastern District of Michigan, 1999, where they have a legal and moral duty to speak and agree that if they, offerees 1 and 2, try to impair this quasi-contract, argue or try to litigate this case further, instead of dismissal with prejudice, agree to give me $1 million in their individual capacity via Holland versus Earl Graves.
$1 million, as in like $1 million gold and silver coins. Okay, people are asking in the chat like why the judge is letting him go on. Well, given the external circumstances, I'm going to say that because we're in what is obviously a pretrial hearing, this judge has probably already heard this guy before. She already knows who he is, what he's about, because at this point he's already been given standby counsel. So I think some people were alluding to this earlier. I think Gary mentioned it. Is that she's probably doing the Judge Darrell strategy, which is to give him that little bit of leverage, or not leverage, but a little bit of leeway to let him say what he wants to say, but ultimately, redirect everything back to the normal course. Maybe that's basically where I'm going. That's my prediction, but we'll see, because again, I've only seen the first 20 minutes of this hearing. I haven't seen the entirety of it.
Code 46, Federal Subsection 681 at 685 through 687, Eastern District of Michigan. Then there's affidavit of truth. I, Carnell M. McQuarrie Eel, says that the above is true and correct, and email these pleadings to Offerees 1 and 2, which is Kim Worthy, as well as this court on May 10th of 2023, and I signed it. The law is clear, Judge, and this court must enforce the law as written by the higher courts. This court is an administrative district court acting on a corporate level, and they cannot conflict, basically issue their rulings in conflict with federal Supreme Court ruling, which they have taken an oath to do so. If this honorable court refused to do so, it would be treason against the U.S. Constitution. And I ask that this case be dismissed at this juncture, because statements, I have not been given anything by the prosecution and the people. And I would also ask that this court exercise the subpoena power and have Kim Worthy come here. She's not God. She's not a queen. She's not an empress or anything. She's an elected official. And her history precedes herself as committing crimes against citizens like Devontae Safford, Darrell Siggers, all these people that they're saying that they're trying to help get out of prison under the wrongful convictions unit. Valerie R. Newman was my former attorney, and that also makes it a conflict of interest, because Judge Kirsten Frank Kelly heard her on appeal. She let the judge do it, and I had to do almost 16 years in prison for a crime where there was no legal jurisdiction at all. And
Well, if jurisdiction wasn't actually said before, I definitely heard it there.
There's documented evidence, paperwork, court seal, signature, and
But it also sounds like, well, okay. At this point, I don't know whether or not he's if he went Moorish while in prison for his first stint, or he's always been this way. I'm not sure yet.
being criminally retaliated against by the people. There's no way they can wiggle their way out of this. And I would like these things to be adjudicated and evidence. I would like an evidentiary hearing so we can admit evidence and or suppress evidence. I haven't been given discovery. I didn't even know I had court the first time I came. I had to go online and look it up. These are the games that they're playing. And I would like their oaths of office, their bonds, as well as other things. Because they're committing felonies, Your Honor. All due respect, like I said, I don't have anything personal against this court or anything. I just request that this court adhere to the supremacy clause of the U.S. Constitution and hold that these state statutes in which they have me charged with are constitutional based on the U.S. Supreme Court. And what is the case? The Shaney versus Winnebago Department of Social Services, there was a young child whom the mother relays that the father was beating the child, and the child died. The mother sued all the way to the U.S. Supreme Court. And the U.S. Supreme Court held that no matter how bad or gruesome that this case was, when it concerned the case, that the states have no duty to protect citizens from other citizens. Anything that compels performance, there has to be a contract. And again, I reserve my rights under UCC 1-308 and the common law UCC 1-1.
So is he admitting? Is he admitting to? Is it? I don't want to say he's admitting to anything, but it sounds like he's implying that it doesn't matter if I did the most heinous act. The state doesn't have any obligation to do anything about it, as long as whatever I did was against another private citizen. Did he mention USCC? Hold on, we're gonna rewind about 20 seconds.
How bad or gruesome that this case was when it concerned the case, that the states have no duty to protect citizens from other citizens. Anything that compels performance, there has to be a contract. And again, I reserve my rights under UCC 1-308 and the common law UCC 1-103.6. And it's clear, Your Honor.
So UCC and somebody that Pope Scriptcat did she get bingo? Nice. All right. Oh, he did say common law too. But we're resetting. Congrats, Scriptcat. Send me a message on Discord. You know where to reach out to me. And we're resetting, people. Everybody reset. Actually, no. Don't reset. Don't reset. We're gonna keep going until somebody else gets another bingo. How about that? We'll keep everybody keep your boxes checked. We're gonna keep going until somebody else gets another bingo.
And I ask that this court, do their sworn fulfill their sworn oath under the Michigan rules, the Michigan Judicial Code of Conduct. The court is not to be swayed by public opinion or what the people may think or whatever it may be. Like the great honorable Judge Dalton A. Robinson, when he was in office many years ago, he did the right thing. They tried to get him to send these young juveniles to prison. He said, no, these young men can be rehabilitated. And he sent them to juvenile prison. At this time, the prosecutor then went and attacked this judge. You see what I'm saying? You have a right and a duty to fulfill your constitutional oath, Your Honor, regardless of what they think about you or whatever else. These these statutes in which they're charging me with are unconstitutional. I never signed any agreements with the cities, counties, states, or whatever else to be governed by them, to adhere to their statutorily incorporated statutes, which in Coins versus Virginia clearly states this is what the system is about. To create penitentiaries, to create prisons.
No, he needs to say statutes and codes. He's only saying statutes. He's only saying corporate statutes. He needs to say statutes and codes.
Hospitals, graveyards, streetlights, so on and so forth, in which today we live in this society. This society is clearly the matrix. The legal system is unconstitutional. These are corporate entities.
Settle down, Andrew Tate.
They're no different than any other corporate enterprise when they provide services for the citizens. The case law clearly breaks it all down. I've never surrendered my sovereignty. Dred Scott versus Sanford clearly stated that blacks could not be.
Look, we live in a society that, all right, look, we're playing Moorish sovcit bingo. We're not playing like cringy red pill influencer bingo.
Citizens were never intended to be citizens, and we were 3/4 of human beings. But under the democracy, pardon, 3/5. Okay.
I like how the judge stopped at that moment to correct him on that it's 3/5, not 3/4.
3/5. Under the democracy, which is nothing but the mob rule of the old South and European inhabitants of this country. If someone killed someone, stole something, they were all the mob who go out there and hang them and do whatever else. So every government is entitled to a Republican form of government, not a corporate. I'm not a corporation, right? I'm a natural person. The case law clearly breaks everything down, which everyone is in default, So I just ask that this court dismiss this case at this juncture. If the court does not, I demand under the Supremacy Clause, the subpoena power of this court, to have Ken Worthy brought in so we can have an evidentiary hearing before we go any further. Because how can a criminal prosecute or allege that I'm a criminal when they're committing all the crimes, Judge? Since I've been home, I've been making reports of police and other things, violations of law against me at the precinct. And no one listens to me. They just ignore me. But when people call and say, well, hey, Mr. McCurry did this, Mr. McCurry did that, they come, then it's found out nothing happened. You see what I'm saying? Like, they even borrowed me from the Secretary of State because I was in there trying to conduct business. Oh, well, we got a call that you threatened somebody. Oh, we found out.
I like how he he casually mentions an incident where he went to the Secretary of State's office and had to be kicked out for allegedly threatening somebody.
You're free to go, but they just don't want you in here. That's not how this government works. Or the so-called democracy in which you guys call it, but it's supposed to be a Republican form. So.
Okay, people have to respond.
Thank you, Your Honor. We're here because Mr. McCrary, the defendant, is charged with 10 felony counts. I've heard a lot of law quoted today. Everything from contract to treaties, corporate, but the only type of law that matters today is criminal law. And under our state constitution, this court has jurisdiction.
10 felony counts. Attempted murder, attempted SA, multiple counts of possession of a dangerous weapon by a felon, and I think assault with a deadly weapon.
Article 4, Section 15, the circuit court shall have original jurisdiction in the matters not prohibited by law, appellate jurisdiction from all inferior courts and tribunals except for otherwise provided by law, prior to issue here and determine prerogative remedial writs, supervisory and general control over inferior courts and tribunals within the respective jurisdictions in accordance with the rules of the Supreme Court, and the jurisdiction of other cases and matters as provided by the rules of the Supreme Court. There's MCL section 767.1, several circuit courts of the state, the recorder's court, and any court of record having jurisdiction of criminal causes shall process and may exercise the same power and jurisdiction to hear, try, and determine prosecutions upon information for crimes, misdemeanors, and offenses, to issue writs and process and do all other acts therein as they possess and may exercise cases of prosecution upon indictment. And the Michigan court rule, which are passed by the Supreme Court, Rule 6.008, Criminal Jurisdiction, Section A. The district court has jurisdiction over all misdemeanors and all felonies through the preliminary examination and until the entry of an order to bind the defendant over to the circuit court. These laws clearly state that this court has jurisdiction over these criminal matters. Furthermore, as far as discovery goes, I personally sent Mr. McCrary twice the discovery material. And I have the emails, copies of the emails to show if that's necessary.
I know, Mash. It's not like I have filters going on with the YouTube audio. The only one I have is I have a ducking, so the volume will lower whenever I'm talking. But beyond that, I have no other, at least, filter on my end. All the filters are on their end, unfortunately.
Dates are not on here. May 24th, which was last week, and May 5th. So we sent in the discovery that we have twice now.
What email?
And
I'll just ask what email, because it's not here.
the second email, I paste and copied off the email that I received from with his documentation. Just here. So the people would ask that defendant's, motion be denied, and this matter is set for preliminary examination, where the people will have to show by probable cause that that a crime was permitted in the jurisdiction of this court in Detroit, state of Michigan, county of Wayne, and that crime under probable cause was committed by Mr. McCrary. Thank you.
Greg, you have a chance.
Can I have a rebuttal? A rebuttal, okay, thank you, Your Honor. This gentleman, what's your name again, sir? Sawaki. Ms. Sawaki must be, in no disrespect to him or the court.
We're going to disrespect.
Well, no, I'm not.
With no disrespect, but he's also like, the judge is like, don't disrespect him. But he's like, I'm not. But we all know he's about to disrespect him.
Now, what I'm saying is, based on his analogy, he's very delusional because.
And then proceeds to disrespect him by calling him delusional. Well, I mean, I call this individual delusional, but I wouldn't say that in open court, though. That's the thing.
The supremacy clause overrides state constitution as well as state laws of Marbury versus Madison, 5 U.S. 137 since 1803. Secondly, in Shaney versus Winnebago Department of Social Services, the U.S. Supreme Court is clear in 489 U.S. 189, 1989, and the civil rights cases, 109.
Yes, thank you for being a 2-month member.
3 says the court held the 13th and 14th Amendment did not empower Congress to outlaw racial discrimination by private individuals, as well as the Shaney. They don't have a duty.
Well, it's a good thing this case isn't about racial discrimination amongst private individuals, now is it? So what does that case have anything to do with what we're dealing with now? Which you are charged under Michigan law that you're being charged with serious felonies under Michigan law of attempted murder, among other things. That has nothing to do with somebody, disliking another person because of their race at a personal level, at a private level. So I don't know why you're citing that case.
To protect citizens under the 13th and 14th Amendment. Give me 1 second. Okay, give me a second. Okay, on page 10, the court held, the U.S. Supreme Court, under the Supremacy Clause, which is he is bound because, Judge, if you rule against me today, you must hold him in contempt of court and also hold him in treason. The court held,
must hold him in treason if she rules in his favor.
The legislative authority of the Union must first make an act of crime, affix a punishment to it, and declare the court that shall have jurisdiction of the offense. Certain implying powers must necessarily result to our courts of justice, but jurisdiction of crimes against the state is not amongst those powers, Judge. See Hudson versus Goodwin, 7 U.S. 32 at 3.
But these are crimes under the state of Michigan. What is he talking about? Carl B, thank you for the 5 gifted memberships. Hold on a second.
That shall have jurisdiction of the offense. The legislative authority of the Union must first make
the legislative authority of the Union, meaning Congress. So why are we even here? Why are we even talking about this in the first place? We're talking about the authority of Congress, not the states.
An act of crime, affix a punishment to it, and declare the court that shall have jurisdiction of the offense.
Right. If in order for a court to have jurisdiction over a criminal offense at the federal level, Congress has to pass a law creating that offense, outlining the elements, and so on and so forth. Again, we're in Michigan. We're talking about a state-level crime.
Certain implying powers must necessarily result to our courts of justice, But jurisdiction of crimes against the state is not amongst those powers, Judge. See,
Right. Right, because because the states have the authority to enact their own criminal statutes. The states have the authority to establish their own criminal laws. Yes! Why? But this is Congress, not Michigan.
Hudson versus Goodwin, 7 U.S. 32 at 33 and 30.
Also, the fact that he's citing the quote that he's got is talking about the freaking union means that we're talking about like the 1860s level case.
34, 1812. This is still good law, Judge. He's arguing a state statute or a state constitution.
Yes!
The state received its power from Congress. So how can you buck the system which gave you?
You moron. We have what's called a federalist system. The 10th Amendment specifically grants the powers of the police, is explicitly regarded as granting the police powers of the state to enact their own criminal statutes. Unless he's trying to argue that all criminal law has to be passed by Congress. So murder has to be a federal law. But he's an idiot. He's an absolute idiot. I can't.
You power to act as a corporate organization. Michigan became a state in 1829, which Congress gave them their power. The U.S. Supreme Court clearly says that, like they say, people of the state of Michigan versus me. You're saying I committed a crime against the state. The Constitution just clearly says that from the U.S. Supreme Court justices in the unanimous decision in which this court, as well as the prosecutor.
Yes, you committed a crime against the state of Michigan, against the people of the state of Michigan. The court case you're citing is that Congress cannot pass a criminal statute on behalf of the state of Michigan. In other words, Congress cannot pass a criminal law saying if a person commits the crime of murder within the territorial boundaries of the state of Michigan, then they shall be punished. It shall be punishable by X, Y. That's what the court is effectively saying there.
Under Article 6, Section 3, the executive department has sworn to uphold, as well as the lawyer's oath in the Michigan Bar Journal. Amongst other things, they're committing felonies, and this court cannot conspire or enter into conspiracy with these individuals to violate my constitutional rights, Judge. And the law is clear. One more thing, if I may. My driver's license.
Uh-oh.
Page 20.
You have one?
Pardon?
You have a driver's license?
Yes, ma'am. But let me, I'm about to go
So he has a driver's license.
here and agree that at the onset of these unlawful attacks by the corporations and its criminal agents, that he did reserve his rights under UCC 1-308, MCO 440-1308, UCC 1-103.6, Siege offers driver's license. I reserved my rights on my driver's license, Judge, so the state knows this. I've never entered it because I was compelled to have a driver's license.
Okay.
And what I'm saying is they're committing treason.
First issue, can I see the emails? I just want to make sure that.
I can give you my phone. I've never got anything. I have to show where I sent him the stuff, but I never got nothing back.
No, let's say I just need to see.
No.
This is your email address.
It's Carnell, CARNELL, MCCRE@gmail.com, which I wrote it down for him.
C-R-E?
Pardon?
Can you spell the whole thing again?
It's Carnell McCrary, MCC. It's my first and last name @gmail.com.
CMCCR.
EARY.
Okay.
Also, there's a case I didn't bring with me today where concerning this type of document, he's trying to title this motion, Judge, so it's a quasi-contract, which is recognized by the Michigan.
So the prosecutor's motion is actually a quasi-contract. Got it. Oh man.
For you to us what it is.
Pardon?
If it's a quasi-contract, he believes it to be a motion.
Well, I mean, it's
that's
clear.
the way it is. That's what it is.
Well, the federal law says that he cannot just see and hear. The Supreme Court said that I'm the legislator of this contract.
Okay.
The litigation.
Yeah, if you're contract-
What?
Yeah, this is in the Supreme Court. They have to obey the Supreme Court. Object.
What part?
I object, Your Honor.
There are some elements that people like to respond to.
Sure.
I haven't
I
finished my
just want to
oration.
get some discovery.
Haven't-
I'll give you can, it's gonna take a couple seconds. One of those emails, he is missing in there.
That's not my fault. They violate your order.
Can I
Yes,
go?
ma'am.
Okay. Is the other one?
One of them has it spelled correctly,
Oh my God, the printer.
one of them does not.
So you should have received one of them,
Nothing.
Right.
and neither one of them came back as a bad email.
Okay. All right, so Mr. McCurry, I don't know why you're not receiving discovery, you did not receive it?
He didn't send, can we subpoena Google and,
No,
No, we're not going to subpoena Google because your email when they ever, so it sounds like the prosecutor saying that we sent him discovery, but we kept on getting bounce backs from his email address. But no, we're not going to subpoena Google. For God's sake.
litigate this and
this
show that
is
he
not,
hasn't
this is
sent
not a
anything.
trial, this is not evidentiary hearing.
Well, can I say one more thing?
After we get done today, we confirm your email address, you can send a test email to make sure that he received it.
Well, he did. It showed me that he got my paperwork. He admitted in the last receipt that he received my
Okay,
paperwork.
and
So why would he send it? Well, why wouldn't I get it back? My email is legit. It's my phone right here.
okay,
Also a jurisdictional challenge.
let's,
Robert.
before we get to that, Adrian or Stetson, you want to respond before we forget?
Yes, Your Honor, I do want to make a record. You know, this defendant has already availed himself to the jurisdiction of the courts of the state by admitting to having a driver's license.
I mean, by virtue of his appearance, he's already acquiescing to the jurisdiction. But I do appreciate her pointing out the fact that he has apparently a valid driver's license is also a clear-cut indication that he's acquiesced to the jurisdiction of the state of Michigan.
Also further add that the 10th Amendment has allotted and given complete powers to the states, which then
Hey, 10th Amendment! Hey, I feel like she knows. She knows. I feel like this prosecutor, she knows. She knows what's up.
allows the state to create criminal laws under which this defendant must avail himself to. I further add that, again, as the court has acknowledged, that this defendant has at least once received the discovery to his emails, to his correct email. So any more allegations of not receiving discovery would be improper, given that we have it at least proven that he has it at least once. And there have been no additions or corrections since the discovery was done the first time.
Okay, and I think she also said that he's at least acknowledged at least once beforehand that he's received discovery. That he has, in fact, received discovery via email. And there have been no changes or modification or additions in discovery since then. So him complaining about him not getting any discovery at this juncture is a moot point.
Okay,
May I
Mr.
respond?
McCurry, I'm gonna wrap this up, you can respond and.
Yeah, just briefly if I may.
Sure.
Well, this young lady here to basically
Young lady.
Mr. Sessions,
respond to Mr. Sessions to respond.
Seriously. Yeah, you come on, dude. I mean, we all know, but yeah, that's also very disrespectful because he actually asked the male I want to go this route with the isms necessarily, but he specifically asked the male prosecutor for his name, and he didn't bother with the female prosecutor's name. He just went this, young lady.
Respond to her statements in Michigan. They're locking people up for not having a driver's license. I was compelled.
There are people getting
But I
locked up
reserve my
for
rights. This was the
murdering
law.
people as well.
Pardon?
People getting locked up for murder as well.
Well, I understand that, but what I'm saying is the corpus delicti, they're going off written statements. You know the corpus delicti rule under the Michigan Supreme Court case, as well as the federal court case. Where's the body of a crime? They're saying ammunition, all this, that. Where's the guns at? Where's the victim at? Strangulation, where's all this? Where's the medical
I wouldn't
reports?
know because we haven't
And
had
then-
an exam.
We haven't had the trial yet.
Okay, but no, jurisdiction, once it's challenged, it must be proven by the people. This is state and federal law, from the Michigan court. So I'm demanding that I mean, they're already in default, but still again, I'm demanding jurisdiction be challenged, personal subject matter and territorial jurisdiction. Even when I was in prison, I had interactions with Kim Worthy, chief prosecuting officer for the state, and I reserved my rights then in prior proceedings, as well as I was compelled to obtain a driver's license. And I reserve my rights. That's all the law mandates, that I reserve my rights, which I have done. And right now, this lady,
This lady, again.
prosecutor, I can't remember her name.
Of course you don't remember her name.
Mrs. Sisson, Esquire Sisson, and this gentleman here, they're in conspiracy and violating federal and state law. There's been crimes, and I demand that their oath of office, their law, their license to practice law, amongst other things, be given to me, as well as their bond, as well as you.
Shut up, Omega.
Your Honor. Also, like I say, jurisdiction has been challenged, and they have to prove it first based on the case law.
Well, I think at this juncture, they probably already have demonstrated jurisdiction to the satisfaction of the court. Remember, the issue is to demonstrate jurisdiction to the satisfaction of the court, not to you.
Which I have noted in this paperwork. They can't get around that. We can say, well, yeah, they're talking about reserving rights and all that. Okay, but still the law from the state Supreme Court, Court of Appeals, and federal jurisdictions clearly mandates that once jurisdiction is challenged, the person asserting jurisdiction has to prove it. And all they have is statements. Under the corpus delicti rule, out-of-court statements is not evidence, so these charges should be dismissed. Where is the body of the crime, Judge?
Oh my God.
You went to law school, you're a
What are you talking about? Out-of-court statements? Oh, he's just throwing in every legal term of art in there and seeing what sticks. God, this is so frustrating. Oh my God. I gotta, let's go. Let's continue on.
practitioner.
No, because I haven't heard testimony to know.
Well, that's not how it works with jurisdictional
That's
challenges.
how, you know, it works that way. So, do you have any last?
Well, I would like,
Statements, because I'm in
okay, I would like to challenge jurisdiction again, which I have done from the onset of this case, personal, subject matter and territorial jurisdiction. State and federal case law is clear, in which this court being inferior to the higher courts must adhere to their oath of office, their bond, and so on and so forth, their license to practice law, and the Michigan rules of Code of Judicial Conduct, and must compel the people to prove jurisdiction, which they're asserting. Where's the proof? You have to show this court. That's at any stage of the proceeding, the law allows that.
Okay. So on discovery, I saw paperwork.
Uncivil law. Hey, what's up, man? Oh, glad to see you in chat. I know, Juan, I know. Shout out to Uncivil Law in chat. Guys, if you don't know who that is, he's a great law tuber. Check him out. Sub, as always.
Confirming the email address that you provided to the court is now on the record.
Deacon, that's his standby counsel.
I'm not sure if there's an email. Please don't interrupt. If there's another email you would like to be sent to, I will ask the prosecutor to do so. 2, for requesting license numbers from everyone. My name is right here in front of you. You can go right on State
I
Bar.
ain't saying nothing.
RP numbers are available for you to look up as they are for any general public. Okay. As far as venue, jurisdiction, and you mentioned this, you don't know whether I was appointed or elected, I was both. So I took an oath, uphold the Constitution of the United States, the Constitution of this state to the best of my ability. And with that, I hear cases that were committed, crimes that were allegedly committed in the city of Detroit. That is the venue for this court. I know that you disagree, but I am letting you know that's what I have to follow based off of the oath that I took. and the right to have exams.
Kurt. Oh my goodness.
That governs preliminary exam, as well as MCL 676.
Unfortunately, Kurt, I don't think, I believe, pillow smothering is against the RPC, unfortunately.
66.1 talks about your statutory right, not constitutional right, your statutory right to have an exam. And under, let's see here, where should I go next? I'm not going to continue citing the rule of law, but under MCL 600.8317, I have the power to hear preliminary examination matters. MCL 766.1 gives me the jurisdiction, and it states in Attorney General 129, Mich. App 128, specifically page 132, which is the 1983 case, and the district court has no authority to grant a motion for change of venue before a preliminary examination is held. The statute granting courts of record authority to change venue in criminal cases is only applicable to circuit courts in felony cases. We are at the district court level. We have not heard any testimony. I don't know anything about this case. So I am denying your request. I will call a motion regarding venue, as well as jurisdiction, or any allegations at this point that the people have been conspiring or conspiring to commit crimes. I would like to hear the testimony from the allegations, from the information and the complaint. So I would like to set this for an exam date so that we can move forward and actually hear testimony so I can make a decision as to whether or not the probable cause is the crime.
Kurt wanted to go medieval on him. Goodness.
Mr. McCrary, I know you're not happy with my decision. You know the rights, you know your rights and what you can do. You do not agree, but we need to get an exam put on the calendar. And of course, you have a right to an attorney. You have exercised the right to not have one. But I'd like to set a date for an exam and move forward from there. Yes.
May I just place my objections? I mean, you made your ruling, but
And
now
I said I know
place,
you were
yes, now I place my, no, I'm saying I have to do it verbally. I mean, for me reviewing past cases from the higher courts, it has to be in the lower court record. I would ask that this court allow an interlocutory appeal to the Michigan, to the Wayne County Third Circuit Court under
Now he wants to do an interlocutory appeal.
MCR 7.101, 7.102, as well as I would like this case to be removed to the federal court under 28 USC.
And he wants to remove this to the federal court. This isn't a civil trial. This isn't a civil case. Stop it. Stop using words that you don't understand.
1441 through 1449, because this court, with all due respect, has committed treason against me and conspiracy with the state. Because under federal law, I had brought a federal question. Once a federal question is presented to this court must rule based on the federal question, which this court has clearly ignored. Okay, I mean, I'm just saying what the court, what the case law says.
You can't just come in here and raise a federal question and be able to shop and go to a different court.
Well, even the state says jurisdictional challenge.
Well,
I brought both case laws.
I understand that you're making a record, but until the exam is held, I can't change it based off of what.
Oh, no, I understand, but I'm saying you can't make other decisions and rulings of law. May I ask this question? Is it okay for the court to ignore U.S. Supreme Court case law, which is in a superior court to this inferior court here, a district court?
If it's irrelevant to the issues at hand at the state level, yes. If rulings of the U.S. Supreme Court have nothing to do with the immediate issues at hand, i.e., trying to cite civil case law in a criminal action, then yeah, they can ignore it.
And I'll, ask that this be the federal court for adjudication, as well as Wayne County.
And I just
to remove that.
Kerr says, I seem to vaguely recall that certain federal officials can remove criminal proceedings from a state court to federal court in some circumstances. So maybe he thinks, I mean, the only way I could see that occur is if there's an issue of like concurrent jurisdiction, right? So so say for example, if somebody commits like a heinous, like a terrorist attack, right? And there's like concurrent jurisdictions, like the one I can think of off the top of my head is the Boston bombings. What's his face? He had both charges at the federal level as well as the state level. So it could be that his state level case could be, I don't know, maybe postponed while the federal case is happening. I mean, that's the way I think about it. I mean, but if you have a link to me about that sort of circumstances, I'd be for it. But I feel like the only time where you would have a removal action in a criminal case from state to federal is when there's an issue of like concurrent jurisdiction. But that's not what that's not what we're dealing with. He's being charged purely under Michigan state criminal law.
So I can't,
Well,
I can't change venue.
But I'm just saying the jurisdictional challenge, they're bound to respond, Judge. And the case law is clear, and this court is ignoring state and federal case law, which
I
they're
don't believe
supposed
I
to.
am ignoring anything. I've sat here, I have a timer on my phone. I've sat here and listened to you talk
Okay.
for 34 minutes and 54 seconds. So I don't think that I've ignored much of anything.
Well,
The
I'm
average
saying,
judge would not sit here and let you talk this long. There are time limits on motions and requests. So I think I've done a great job of not ignoring. I've heard everything you said. I've read.
And the judge here is saying, I've given you 34 minutes to say everything you need to say. So I appreciate her saying that. I appreciate her putting that on the record. And saying like, hey, other judges wouldn't have given you this amount of leeway. I gave you this much. And I think we've heard all we need to hear.
Read your paperwork.
Got it. 28 USC 1442A. Awesome. Thanks, Kurt.
I've addressed it and responded. I just don't agree with it. So I understand your objection. If you don't agree with anything that I've said, I understand that. And I am ready to set a fan base.
I'm being compelled. May I have your bar number, Judge? Because it's not up there.
Look it up with my name.
I mean, I thought this was public information.
I gave you the freedom to go to the library. So you do.
Ah, okay. So if the issue is okay, so that's okay, there we go. So I'm looking at 28 USC 1442. So if like a federal officer, so say a federal officer or somebody acting under that capacity is charged with a criminal crime, then that case can be removed from state to federal court. Okay, so that actually makes so that makes sense. That actually does make sense. Holy hell, Brad.
And then also, I need their names. I don't know how to spell their names. I mean, can they write their names down for me? So I can file attorney grievance complaints with the attorney grievance commission, Your Honor. I don't know their first and last names. I need this to petition the
I'd
attorney
like to
grievance.
set an exam date.
I mean, I'm being compelled to go to an exam.
So we're gonna.
Violation of federal and state law.
For June. I'm thinking June 13th. I don't know if that works. You go first.
Yeah, that's my birthday. Y'all trying to bring me on my birthday?
Your Honor, I'm not in court that day.
Okay, let's not do that day.
Well,
But I'm not gonna have to do it first.
okay. I mean, I would like their names. That's all I need. So I can go
I
to
would
the
like
federal
their
courts.
exam date.
Things of that name. I mean, I'm being compelled. Judge, right now, you have me here under duress and coercion. I can't even work to support myself.
I allowed you to work.
Well, it's across the street, but that's not every day.
That's what you asked.
And,
for.
and people have been contacting
asked
me.
for.
Okay, no, I understand, but people have been contacting me about a job. I've been in the community. I've been home.
You want to address bond? We can address
Pardon?
bond after we get an exam date.
What Thank you, Deacon, for the 5 gifted memberships. I appreciate it. And now he's what? Complaining about it? Dude, the fact that you're out right now, you should be counting your blessings.
I'm just gonna have a tether on. I'm not gonna run
I
out
don't
the
know
door and let
what
them
you're
get me.
going to do, but I want to set an exam date
I
first.
mean, I'm compelled. You, I mean, that's your
don't-
call. Your call.
Okay, I need to set an exam date still, whether you feel compelled or not.
Yeah. Well, I mean, that explains why he's not in cuffs and he's in casual clothing. He's out. He's out on bond.
June 15th.
I'm here that day, Your Honor.
Okay,
I'm here as a standby, Your Honor.
okay. Mr. McCreary, can you do 9:30?
I mean, I'll be here.
Yes.
Anytime you want me here, I'll be here. But I would also need, I mean, they're saying
Wow,
about,
Brad.
email, why can't they just print it off like they used to back in the day? It's a violation of MCR 6.201, like when I asked for their bond numbers and
Just
other
request it,
things.
ask, you just ask.
That's pertinent. I did, and they
Just
told me they
ask.
weren't gonna do
Your
it the
Honor,
last time we were here.
Mr. McCreary, let the record reflect that I have 15 pages of discovery that I can now hand to the defendant. This is all that we have.
Is it complete? Because I would like an in-camera review.
He literally just said it's all that we have. So now the prosecutor's now putting it on the record. Judge, I'm putting it on the record that I am handing the defendant all the discovery we have, and that's all we have. And he just asked, well, is it complete? He just said it's all we have.
Of your file as well, the MCR 6.201. Can I review his file on the MCR 6.201? So, because they have a history of holding stuff back from, which is all
That's a common
documented.
allegation for people you don't even know.
What, it's not what I'm saying, her office, Kim Worthy's office, they work in behalf, they're her subordinates. Notice the agent is notice the principal, notice the principal is notice the agent.
I'll
Under
put on
state
the
and federal
record
law.
first that Mr. Sawaki has handed over 15 pages of a hard copy of discovery.
Is there medical reports in here as well? Because he said someone was shot and beat up and where's the ammunition? I need pictures of the guns
Read it.
and all the stuff. These fictitious guns and everything that they're talking about they have.
You think that they're going to hand you the guns?
No. What I'm saying is they say ammunition, guns, and other charges. Where's the evidence?
That's
This
what
is
the
just
exam for.
allegations in violation of Opera versus United States. Like even if I went into a precinct and confessed.
Okay, let me get the date, June 15th at 9:30. Big discovery. Provided any additional discovery.
No, Your Honor, there is no discovery.
I would request additional discovery.
There is
if I
no
may.
digital discovery to turn over. The people
Oh,
should
additional.
have it.
Oh, I thought he said additional. I'm sorry. Well, can I request additional discovery because I would like to say this if I may. Kim Worthy, I believe it was
You
last
don't have
year.
to say, you can just ask for a discovery order
Okay.
to sign.
Well, yes, but I would like to tell you why.
I would
For the court
object,
to
Your
rule.
Honor. I'm going to object to the defense bringing up any issues of Kim Worthy and past experiences.
She's
With
the
this court,
prosecutor.
Your Honor, I am asking the ability to speak uninterrupted.
Okay, so all right, hold on. I need to, because this is actually getting serious. Hang on, I was just listening to it because it sounds like he's talking about the alleged victim here. Hang on. He sounds like he's talking about the alleged victim because he was talking about
Like to say this if I may. Kim Worthy, I believe it was
You
last
don't have
year.
to say, you can just ask for a discovery order to
Okay.
sign.
Well, yes, but I would like to tell you why.
I would
For the court
object,
to
Your
rule.
Honor. I'm going to object to the defense bringing up any issues of Kim Worthy and past experiences.
She's
With
the
this court,
prosecutor.
Your Honor, I am asking the ability to speak uninterrupted from this defense.
okay, he's talking about the he's talking about he is talking about the prosecutor.
This defendant has now on more than one occasion raised issues of past cases. Those cases are not relevant to this hearing. The people ask that this court prevent the defendant from raising any issues of past hearings or past experiences with this office so that we can focus on this hearing alone. The people have turned over all the evidence that is available to the defendant. We have turned over everything in our possession that we can to the defendant. If the defendant wishes to seek any other items or specificity, he would have to place that in writing.
Okay, so the prosecutor saying he's bringing up these past incidents or past cases that he's alleging that they were overturned or they were these defendants were found to be exonerated, or I think that's what he's alleging when he mentions these names. And so he's trying to bring in the lead prosecutor as though to try, I guess, to try impinge the integrity of the office. And so the female prosecutor's like, these cases have nothing to do with the instant matter. They're irrelevant. And she's objecting to bringing these other cases in, which I would generally agree. If there was going to be, I don't think this is a Kim Gardner situation. Am I right? We're not. So just because at certain other instances, at some point in time over the, I don't even know how long or in what span these different cases that he's talking about existed in. Just because there were instances where the prosecution may have gotten it wrong and made a mistake does not necessarily mean that they're making a mistake here. And so it's sort of like him trying to bring in like bad character evidence, but on the prosecution side, to try and undermine the credibility of the prosecution. So I think that's what they're trying to head off here.
Well, if I may respond, there's case law from the Michigan Court of Appeals that rebuts what you say. It's for purposes of impeachment. I've done it in many other cases, People versus Satterway, to test the credibility. And this is.
Kurt, do you really think Moroccans want these more sovereign citizens? I'm pretty sure Morocco is actually well aware of the phenomenon, and they sure as hell do not want any of them in their country.
The prosecutor and I both just said that you want to request anything else that we don't know if it exists, but you're right.
Right. Well, my thing is, Mr.
I need you
McCurry.
to acknowledge that.
Oh, I mean, I hear you, and I respect what she's saying, but she's totally wrong. How can you buck the Michigan Court of Appeals?
So what do you want? You just
Well, I was trying to say before she cut me off that Kim Worthy issued a list saying that officers who have testified in the past and falsely in court cannot testify in the future. My brother has committed perjury in Chief Judge Burke's courtroom in Wayne County, and I would like to, and I had the evidence here. I would like to admit it in evidence.
Those are all things that you can bring up during the exam. If he gets to take the stand, you can address all of that.
Exactly. If you're trying to impinge the credibility of certain officer testimony, you can do that during cross-examination. We're not here to do that now.
Well, I'm entitled to an evidentiary hearing to admit evidence.
It's going to be called a preliminary examination. Evidence is going to be provided and presented. Yeah. Complaining when it shows up, okay?
Well, I hope he does, because it's not gonna look good for him. And they refuse to prosecute him for crimes against me.
My question is, do you still want to move forward representing yourself for the exam?
Definitely, yeah.
Okay.
I'm entitled to that under the First Amendment to the U.S. Constitution, Article 1, Section 13.
You mean a Sixth Amendment? Not
I'm
first.
asking you procedurally so that we can be prepared for the 14th, how we're going to do, or 15th, whether you want to turn here or not. That's all. So if you do, Mr. Washington needs to prepare. If not, then we're going to continue our having how we have it.
Well, I request that all prosecution witnesses be put on the stand per the court rule, as well as the defense
You can call them
witnesses.
to the stand. You have a right to call witnesses. So if you want them on the stand, you have to call them as your witness.
I would like to call Kim Worthy. How do I go about doing this? Getting your subpoena power, your assistant of subpoena power to bring her into court. Because the case law is clear from the Michigan Court of Appeals that I can bring in evidence in prior cases where the prosecution has committed criminal and constitutional violations.
I'm not bringing Kim Worthy on the stand unless she was a witness.
I'm saying she's the chief officer.
If she's not a witness in this case, I'm not calling her to the stand.
Well, can I call her? I can call her as a witness, which you just said.
Subpoena her.
Okay, so can the court assist me with that? In the subpoena?
That's what you have Mr. Washington for. I'm not involved in helping you with your case. That's not my job.
Well, sua sponte, the law says sua sponte, you can.
I'm not helping you with your case.
I mean, I'm not trying to get you. I'm saying so far as the issuing the order for subpoena to bring her in, as well as other witnesses. I have other witnesses.
Mr. Washington is a very
Okay, sorry. Kim Worthy. I keep mentioning Kim Worthy is the prosecutor for Wayne County, Michigan. I assume Wayne County is where Detroit is located.
trained and knowledgeable attorney who tell you what you do if you like to. All right, anything from either party.
Can you give me your name, sir? And both you guys' names, so I may,
File a grievance.
I mean,
Who's gonna
have a
willingly
right.
say, here's my name, so you can file a grievance?
I mean, that's
Put
the
a lien on my
law.
house.
This is the law. the
Your
law
Honor,
for the Michigan Supreme
Your
Court.
Honor, just so that the record is clear, both Mr. Salviki and I placed our names and P numbers on the record at the start of this case. Our names
I
are
don't know how
also
to
in,
spell that.
our names are also in emails that were sent with the discovery to the defendant.
So we're gonna go off the record. We're done with this for today. I don't know why you're not.
Oh, and that's it. That's all we were able to get. Which is annoying because it sounds like it went on further, but oh well. So no secondary bingo. All right. People are saying there's a new CBC. Oh. Oh, they went off the record. Gotcha. Oh gosh. All right. What's this gonna be about? And then we're gonna end it here. The title is Woman Gets Caught Trying to Steal $800 Worth of Makeup.
On December 11th, 2022, police were dispatched to an undesirable case at CVS Pharmacy in Eau Claire, Wisconsin. Staff reported that a female inside the store refused to leave after being told they were closed.
Guys, if you haven't already, please hit that like button. It really does help the channel. It's always appreciated. Thank you guys. Again, thank you guys for being here watching. I appreciate all the support you give. Thank you so much, guys.
Closing. They also advised she had stolen from them before, and it appeared she was about to do it again with approximately $800 worth of cosmetics. Upon arrival, the officers told the 23-year-old
No bingo. No more bingo.
later identified as Ada Lee to leave. However, she continued to look through the aisle, ignoring them.
It should be. Hi.
That's her basket right there,
Okay.
and she's not gonna buy that stuff.
Well, how's it going? Good. So, sounds like the store doesn't want you here, so you're gonna have to grab...
Okay, the fact that she's hitting a beat in the middle of the store tells me she's probably on something. My God. Woo!
Okay.
Why is every a cop collar?
What's that?
Why is it a cop collar?
Hey,
What?
listen.
What?
Put your stuff down, and you gotta leave. Yes, or else I'm gonna escort you out.
Oh my god.
Put your stuff down.
No, I don't want to.
I didn't ask you. I'm telling you, put your stuff down.
Oh my...
We're leaving.
What the fuck, dude? Asshole. What is good?
I'm telling you to do what I already told you to do. Grab it. Give me this stuff.
When Ada Lee was leaving, the store alarm went off due to the merchandise she had concealed.
Naturally.
But first, let's hear a quick word from today's video sponsor, Bullet Safe.
Bullet
Bullet
Safe.
Safe offers top quality, affordable bulletproof vests like the VP3, designed for breathability, flexibility, and mobility with excellent protection against most handgun calibers. In addition, they also offer various defensive products like a tactical plate carrier kit that ensures the utmost level of protection and a bulletproof backpack panel that can transform any backpack into a shield. Bullet Safe strives to be the leading provider.
I mean, you kind of need that if you're going to Detroit. Thank you, Joan, for the 99-cent super chat. And Chicago.
Of body armor and personal security products. Click the link below and use discount code CBC10 to get 10% off your order.
You have activated our inventory control system. Please return to your cashier and we will complete your transaction.
I don't steal, I take. So,
Come here.
that's why I don't.
Come here.
Does that mean she took something?
How's the person there? How's the person there? No, I didn't steal anything. I didn't.
Okay.
I didn't.
Stop.
I didn't steal anything.
Then why is your alarm system
You can
going
go in
off?
my bag.
We are. We're going to.
Okay, but I didn't steal
Take it off.
anything. That's all my shit that I bought.
Yeah.
But I left my purse in there.
Yeah, all right. I thought that dude looked like Chuck Liddell as well.
I'll get that here in a second.
What the fuck are you doing?
Stop.
Don't you fucking do that.
Stop.
No.
You're gonna be in cuffs. You're going to
No,
police.
I'm not.
Yes, you are.
What the fuck?
Stop.
I will kill you.
That's fine.
Why would you say that to a police officer? I know why. Because she's probably on something and is a moron.
Yeah, they ain't gonna kill you.
Yeah.
What the fuck are you
Put your hands
doing?
behind your back.
No.
Okay, we're done. Hands.
She then stated she was in a gang called the Gangster Disciples. As a response, the officers exhibited no concern and swiftly decentralized her.
I'm in a gang. I'll fucking.
Decentralized drink.
What the fuck?
Get out.
Stop.
Stop. What did I do? Knock it off. No.
Stop.
Knock it off.
Stop resisting.
Knock it off. I'm a disciple. I'm a disciple. Knock it off. Knock it off.
Stop. Stop kicking me.
Just stop.
Well, I'll be damned. The Gangster Disciples, often abbreviated as GDs, former GDN, are an African-American street and prison gang. Okay, I had no idea. I guess I'm that far gone. I actually did not know Gangster Disciples is an actual street gang.
Hey, can we talk?
No.
Please.
We are far past that.
And I'm pretty sure, just like other gangs, they don't take kindly to people claiming they're a member when they're not actually a member.
Guys, I'll kill you.
Stop trying to scratch me.
I'm begging you. Guys, I'm begging you, please.
Stop trying to scratch me.
Please talk to me. I mean, please talk to me.
No, we're past that.
Please talk to me. Guys, talk to me. Guys, you can search me, I promise.
Affiliate status.
You can search me, okay? You can search everything. Okay? Guys.
Stop talking.
I didn't steal anything. They're all watching. They're gonna kill. He's coming up right now. He's coming up right now. Stop! He's coming up right now to kill you. Stop!
Stop threatening.
Please.
Oh my God! It's T-Rex 3.0. We found another T-Rex in Wisconsin.
Stop kicking me.
I'm sorry.
Then stop.
I'm sorry.
It's not that hard.
I'm sorry. You're right.
No, you're not.
The first T-Rex was Noah, the dude who kept talking about he needed to go to take a poo. The second T-Rex was the lady who was drunk and talked about how her brother died like 6 months ago. That was T-Rex number 2. And this sounds like T-Rex number 3.
Stand up.
All right, let's walk.
Oh, stop it. Why did you go up with me?
You're gonna throw up?
No, I didn't. No, I'm sorry. Did I really? I don't know.
Numerous times.
I did?
Yeah.
I'm sorry. Did I really?
No, Tone's breaking the flaw. He's not a T-Rex, he's a velociraptor.
I mean it. Guys, I'm sorry. Guys, I'm sorry.
Hey, stop talking. Sit down.
I am.
Sit down.
I'm sorry. I'm truly am. I really am.
Go. Lean back. Think someone's done some meth today?
No.
Makeup, Pantene Pro V, hairbrush,
There's this.
eyelashes.
That's better now.
Which
What's your name?
Adeline.
What's that?
Adeline. I did. disciple. I'm a disciple. I'm a disciple.
No, you're not. Okay.
Look at my, take off my jacket. I'm a disciple. Look, I'm wearing it. I'm wearing my jacket. Take it off. Take this off.
Okay, how do you spell your first name?
I'm a disciple. I'm in the gang.
Okay, she's got the crazy eyes. Holy. Those are some crazy eyes, man.
Gang. I'm a disciple. Look at my jacket.
Okay.
Take it off. Take it. So
How
you
do you
can
spell
read
your first name?
it. ADA.
Yep.
That's why I don't want you guys to die. They'll kill you for killing me. They will. My gang will murder you.
Well, it's a good thing the cops aren't planning on killing you.
Okay.
I wouldn't kill you guys.
Okay.
I got you guys back for life.
Right.
Like,
ADA.
what if you killed me? I got you, okay? I care about you guys. That's why I don't want you guys to die.
Okay. ADA.
ADALE. That's my government name.
And
It
then,
is my legal government name.
what's your last name?
Never give it to anyone. ADALE. That's my real name, I swear.
It's so hard to tell, like, what is stolen and... Right.
Did you find an ID? I have zero idea what she's even telling me for her actual name. Adelie something.
I'm a disciple. I'm in a gang, I'm a disciple.
Perfect.
I care about you.
Okay.
I don't want you to die.
What's your first name?
My gang would kill you. That's why I told you guys to stop. Okay?
What's your first name?
I will protect you.
What's your first name?
Adelie.
What is it?
Adelie.
Adelie?
That's why I'm gonna stop because I don't want you. I care about you.
Sperry.
I found her. Yeah. That's what meth will do.
Yeah, she's losing a lot of weight. She's a disciple, just so you know. She's not gonna hurt you, but her gang will.
And I told her, I was like, no, you're not. And then she
went sideways?
Yeah, she freaked out. Nothing open, no probation, no warrants.
So just resisting the threats to law enforcement?
Threats to law enforcement, battery to law enforcement, and then the resisting.
I guess I'm just gonna take all of that. That one looks brand new. That one looks brand new. I can't tell if this is used. I'm assuming she took that out of a box. This has never been touched. It's so hard to tell.
What is it that you didn't take?
Probably, Deacon.
All that stuff is mine that I bought. The only stuff that I didn't buy. I didn't buy all the stuff that was in the basket in the store and what you guys took on my. All the stuff in my bags is mine. You put it on me. I
What?
put it on my gang and God.
Okay, and there we go.
Did you say put it on my gang? Like, do the disciples have like an open tab with CVS?
I'll take this back.
Check if this is theirs too, because like this has like a cover. Like I said, there's just so much that I couldn't even tell you what is and what isn't. But obviously she had something if it was going on.
Yeah, I like how you also broke the glass.
Oh, I know. I was like,
so great. Get right off the rail. I'm assuming these are ours. Yeah. So.
Thing is, when she came in, that went off. So
Oh,
I
really?
wonder if she brought these back from
Probably
stealing it.
the first time.
Yeah. Yeah, it's ours.
Okay.
If she never comes in here again, that's fine with me.
Perfect.
We don't want her back.
Will
You
do.
can do whatever you do with the charges.
Okay. All right.
I appreciate you guys coming.
Absolutely. How long was she in here
She was in
before?
here for about 20 minutes.
And just had a pile of stuff
Yeah,
on.
I was gonna let her go, and then she's rolling around on the floor there, just pulling shit into that basket.
Mhm.
You gotta go. I go, we're going to lunch. We're locking up.
Mm-hmm.
And I go, I'm gonna call an officer, and she's like, it didn't matter.
Mm-hmm.
So,
Yeah.
you gonna arrest her or what?
Yeah.
Okay.
Yep. She's going to jail. So.
I promise you, I'm not lying. That I was gonna buy out stuff in the store. And what is my bag? It's mine. What you can hear
all right, if you've ever worked in retail, I've done it before where I've said I'm going to lunch. When I worked an evening shift, I've said it myself where I would say I'm going to lunch as in I'm taking my hour break to eat something during an evening shift. I called it going to lunch, even though it's like late evening.
I'm not lying that stuff anymore.
Is she from around here, do you think, or?
She was listed as homeless out of Eau Claire, so I'm assuming that looks like we've dealt with her before.
Yeah. She's been in here before, and
Yeah.
the same thing. you know.
Same thing.
That's
yeah.
like $2,000 right there.
Oh yeah.
The cosmetics are not cheap.
No, they are not. So.
All right,
All right.
sir.
Yeah. Let us know if you guys just
You
come
need
across.
anything? No.
Just let us know if you come across anything else that she had some other stuff in there that looked like it had at least been opened and like used. So and like just like used like one time.
Yeah.
So if you come across anything that
That's fine. We're good.
okay, thank you.
That's good. Thank you.
You bet. All that stuff was theirs. So you can
Guys, no. Everything's fine.
Ma'am, I see that you scratched your chin a little bit. Do you need to go to the hospital or get medical attention? Okay, are you injured at all?
Yeah, I am, but I don't know.
How are you injured?
I gotta go. Read it. I'm a GAD.
Okay. Do you need medical attention at all
I mean, the cops like don't care.
tonight? No? Okay. There's your answer.
Thanks.
Yep. Need anything else from her? She's also banned from here, so.
Oh, sweet.
No.
Perfect.
She is no longer welcome.
Thank you.
Are you serious? I'm not being in jail. Huh?
Hang on, I'll tell you here in a second. Yeah, you did.
No, I didn't. What did I do?
So,
I didn't steal anything. I didn't even walk out. No, I didn't.
we found stuff in your bag that they said is theirs.
No.
Okay?
I
And then,
promise, dude, I don't lie. Lying is a sin.
okay.
I will
And
tell
then
you the truth.
you resisted. Then you made threats to us. Okay? And then you were kicking and scratching us. So,
I'm off my meds. So I might have blacked out. I didn't realize it.
did you said battery to public officer, right? For the what? Sorry. Okay. All right. Perfect. Thank you.
Adelie was charged with 2 counts of felony threat to a law enforcement officer, misdemeanor counts of retail theft and resisting an officer. She was released the following day on a $1,000 signature bond. Almost 2 months later, Adelie failed to appear in court and a bench warrant was issued.
Shocker.
She ended up being apprehended the following week for retail theft once more. For that case, she was released on a $500 signature bond. Since then, Adelie has been arrested 7 more times for offenses such as disorderly conduct, threat and bodily harm to a healthcare provider, battery, and numerous drug-related charges. As of today, this gives her a grand total of 9 active cases. Head over to codebluecam.com.
Then she's probably out still. Of course she is. Wisconsin, get it together.
And check out our great selection of quality-made merch that won't disappoint. On February 20th.
No, not doing that. I haven't seen all of Van Balion's latest, but it's a pretty long one, though. I have a little bit left, so this we can watch this one from Van that I've seen a bit of it, but I haven't seen it all, and we'll call it a day. I have a little bit of this atomic citrus left. Oh, hold on a second. I want to make sure that this is actually the last one I got. I think. All right, this is it. It's a short one, 9 minutes.
Okay, so I'm gonna explain this to you. If you don't step out on your own free will, we'll have to break the glass on your truck to get you out. Do you understand me?
I'm having an atomic citrus from Voodoo Ranger. It is a blood orange ale. Actually pretty good. The thing is, this is the first time having Voodoo Ranger. The reason it's the first time, even though they have a lot of varieties, is that all their other varieties are like freaking IPAs, and I'm not a fan of IPAs. So.
Welcome back to the channel, guys. Today we head to Gem County, Idaho, where a sovereign citizen believes he can speed with impunity and drive on an indefinitely suspended license because he supposedly doesn't contract with the state. Unfortunately for him, Gem County sheriff's deputies do not entertain this sovereign citizen nonsense and give him two choices: either step out of the vehicle or we'll bust out your window and pull you out. So let's see which option he goes with.
Driver still refusing to step out of the vehicle. Sir, I need you to step out. You're making it worse for yourself.
I'm not stepping out of the vehicle.
Right now.
I'm not stepping out of the vehicle. I haven't committed any crime. You're harassing me with the rest of your cohorts. You've been harassing me.
You've been harassing. I don't know who you are. You won't identify.
Exactly.
I like how he says the word exactly, like the deputy made his point for him, when the fact that the deputy, not knowing who this guy is, debunks that nonsense. Even if it was, it's still not harassment because you're driving on a suspended license, so you shouldn't even be on the road in the first place to be caught speeding. Unbelievable. Anyway, back to the lunacy.
Because I haven't committed a crime. That's a secondary offense. I haven't committed a crime.
I don't know what you're talking about, secondary offense, because a speed...
In order for you to ID me, I have to have committed a crime.
Well, what do you think speeding laws are? They're not mere suggestions. Speed limits aren't there for advice.
Okay, so you guys already know this, but just to clarify, just because a traffic violation isn't technically a crime in many states, the statutes still say that if you're stopped for a lawful traffic stop, you are required to provide your identification to the officer upon request.
They are laws. Look, you can play these semantic word games all day long, but the bottom line is speeding is against the law, and seeing as you're driving while you're doing it, that gives this deputy all the probable cause he needs to pull you over and ask for your details.
I need you to step out of the vehicle.
Sir, that's not happening. I haven't done anything wrong. I haven't broken the law.
Either way, okay?
Oh, I know. It's all on camera. It's all going to be on camera. I fucking cannot believe this fucking shit.
You could have made it easier on yourself just by IDing you, but you didn't.
I haven't done anything to ID myself. I haven't committed a crime. Okay?
Do you have a driver's license?
No. I don't. No, it's indefinitely suspended, okay? And you know what that means? It means I don't have a contract with you guys, which means you guys...
And what did you do? What did you do to get your license indefinitely suspended? Dang.
You guys do not have a right to fuck with me, which means I don't have a right... I don't have to...
You're suspended, which means
no, indefinitely, which means I don't have a contract with you guys. Which means I don't have a contract.
Yeah, translation. My license got suspended. I looked for ways to resolve it, but Google recommended sovcit websites and YouTube recommended sovcit videos. And the rest they say is history.
You ran my plates, right? What's it say? Oh, you didn't run my plates? You just pulled me over? Without running my plates, right?
Sir, I told you why I stopped you, okay?
Which is a lie. Which is a lie. I just came around the corner when I passed you. So I was speeding then, huh? Okay. Is that your answer?
Well, he pulled you over, so yeah, I guess it is. Arguing about it at the side of the road isn't where you resolve this. That's why we have courts.
Okay, well, here he is, violating me, touching my property. Stop touching my truck.
You're gonna step out of the vehicle.
You're on camera, just so you know, deputy. What's your name and badge number? What's your name and badge number? Name and badge number. Come on, for the camera. Name and badge number. Oh, here they go. They're going to break into my truck.
Well, not if you comply with the law. Actually, all you have to do is unlock your car door and step out of the vehicle. On second thoughts, you're driving on a suspended license, so you don't really give a damn about the law.
Hey, what's going on, man? I have a right to travel freely. I haven't broken the law. I shouldn't have to ID myself. Hey, sir, just calm down, all right, man?
Mm-hmm.
I have a right to travel freely.
Sir, you were driving. We need to see your ID.
I have a right to travel freely. He has no business to ID me.
Sir, do you have your last name is Olin, right?
He has no business to ID me.
Well, he does.
No, he don't. I hadn't committed any crime.
For the millionth time, yes, travelling is a right, but driving is a privilege. There is a big difference. And in Idaho specifically, a driver is defined as every person who drives or is in actual physical control of a vehicle. Yep. So yes, because he suspects you of speeding and driving on a suspended licence, this deputy has every right to identify you.
I got plenty of lawsuits coming on you guys already, just so you know.
Because they've never heard that one before.
You guys can join the party. Now there's only 6 of them here. Intimidating, threats, and coercion.
Oh really? Intimidation, threats and coercion? This coming from a guy who not 30 seconds ago threatened law enforcement with a frivolous lawsuit for simply doing their job correctly.
True. Exactly. How is what you just said not an intimidation tactic?
Unbelievable. What a hypocrite this guy is.
So you're gonna have to
under threats and duress.
Because I don't want to damage your property to get you out.
What's that?
What did sovcits do before cell phone cameras? Probably the exact same thing we're seeing now. It's just that they didn't have smartphones or to record their interactions with police. But that is actually a good question. I mean, a lot of the time sovcit paperwork goes back pretty far, like in the court system. But you're right. These video interactions, yeah, 2010 plus.
You need to unlock this door.
You need to let me go park my truck right back there.
That's not gonna happen. You need to unlock this door.
Such bullshit. Here we go. There's only 6 of them deep.
They're 6 deep because of your behaviour, because you are refusing lawful orders. Plus, we didn't see it, but I would bet serious money that you're the reason they're here, because you demanded to see a supervisor. Because you're a Karen. Sovcits are Karens. They demand supervisors. That's what they do.
I've done nothing wrong.
Sir, I need you to unlock this door. I don't want to have to damage your property.
I've done nothing wrong.
Yes, Jassa. The sovereign citizen movement has been around since the late 60s, early 70s. Juan Galt would know better than I about the history. But they've been around for a long time, long before smartphones.
Right, so now they give him an ultimatum. Step out of the vehicle or they break his window and pull him out. So let's see how smart he is.
Okay, so I'm gonna explain this to you. If you don't step out on your own free will, we'll have to break the glass on your truck to get you out. Do you understand me? Because I would rather not damage your property.
And why would you want to damage my property anyway? Why would you want to damage my property anyway?
Are you listening to me at all?
Why would you want to damage my property anyway?
Because I have to get you out of the vehicle and you're free.
Oh, you have to get me out?
Yep.
Oh, fuck, man. You guys are so fucked, dude. Get the fuck off me, man. Jesus Christ.
So it turns out he was only slightly smarter than the average sovcit by choosing to step out of his truck before they busted his window. Never mind, there's always a next time. And it looks like they probably charged him with resisting arrest also, because in part 2, which is only 13 seconds long, he complains about just that.
Oh, really?
Have I ever resisted you guys? Give me a fucking break. You don't need to fucking yank on my throat, you fucking prick.
And there we have it. Another sovereign citizen gets awarded a pair of silver bracelets and free bed and board at the Grey Bar Hotel. Link to the original video is in the description. Right, thanks for watching guys. If you enjoyed this video, then please leave me a like, share the video and subscribe to the channel. Thank you also to my channel members and patrons for your continued support.
As you can see, the more you around, the more you're going to find out.
And that's what happens. Thank you, Van Balian. Shout out to you. Thank you guys for hanging out with me this evening. Like I said, I'm gonna try my best to get back into my regular schedule, which is Monday, Wednesday, Friday. Which it means I'm going to be streaming tomorrow with some more videos to catch up with you guys on. This Moorish individual sounds like it's gonna be a wild ride, so I'm gonna keep paying attention to that for sure. As far as other points and updates, I do want to do another Star Wars watchathon. I'm almost done with the Bad Batch, and so I still want to do a watchathon for Empire Strikes Back and Return of the Jedi. Possibly this coming Saturday might be a good date to do that. But in the meantime, thank you guys. I'm also going to revitalize my gaming channel. My card is here. My graphics card is here. It's running. It's running fine. Knock on wood. So I'm going to be coming back into my gaming channel. Maybe some Cyberpunk, The Witcher. But I'm gonna be honest, I need some comfort food, and comfort food to me is Skyrim with 1200 mods. That's my comfort food. So I might be playing some Skyrim as well. So I want to thank you guys again. I appreciate it. Hope you guys have a great rest of your evening. And I'll see you guys next time. All right. Take care. Adios. Later.
My bitch a choosing love.